Hello, my name is Michael Tesoro and I've prepared this short presentation on the ACCC's proposed merger reforms. Now, a bit of background about myself. I'm a competition and consumer lawyer and I work for my own practice, Tesoro Legal Consulting, for about 13 years. During that time, I've helped a number of companies with mergers. I've also been appointed as an independent reviewer of various ACCC mandated divestitures. Prior to that, I worked at the ACCC in a range of roles, but one of my roles there was as the director in charge of the Sydney Mergers and Asset Sales branch. And in that role, I conducted and managed many merger clearances, a large number of divestiture matters, and also some litigation. So quite a bit of experience in the mergers field for my work, both in private practice and also at the ACCC. Now, just to outline the presentation today, I'll be explaining the context of the ACCC's proposed changes to merger laws. Then I'll summarise the changes and then seek to undertake a detailed analysis of that. And then finally, some commentary on the changes, particularly the likelihood of some of them being accepted by government. So the context of the proposed changes has to go back to April 2021, when three regulators got together to issue a joint statement on merger control enforcement. And the three agencies were the ACCC, the Competition and Markets Authority from the UK, and the Bundeskartellamt from Germany. And they got together to discuss their concerns about the uncertainty that they thought was inherent in the forward-looking approach that merger control took, that it was very difficult to see what was going to happen down the track. Furthermore, they were very concerned about changes in the nature and complexity of mergers, particularly in the digital space. And they were also very concerned about the increasing levels of market concentration in economies all around the world. And that's a concern that's shared by many governments as well as regulators. So then in August 2021, at the Law Council annual conference of the Competition and Consumer Committee, Rod Sims gave a presentation where he provided more detail about the proposed changes that he wanted to see brought in. And in that presentation, he explained that as far as ACCC was concerned, Australian merger laws were failing to adequately protect competition and were not fit for purpose and accordingly needed to be changed. He drew attention to the fact that in some respects, Australian laws are different to laws overseas. He said that the laws are out of step with most merger regimes internationally, particularly in relation to the mandatory notification of mergers. And also he drew attention to the fact there were flaws in the way the law was applied, the legal tests that had to be met in order to prove that an acquisition was going to substantially lessen competition. Another undeniable part of the whole mix is the poor record of the ACCC in merger litigation over the last 10 years. And clearly the attention is focused very much on Metcash, TPG, Vodafone and Pacific National, but they're not the only cases the ACCC has been unsuccessful with. There was also high profile losses in relation to Macquarie Generation AGL, Toll, C-Swift and TATS Tabcorp. So there's been a high number of defeats both in the courts, the Federal Court and the Australian Competition Tribunal. So just summarising the proposals, there's sort of three main areas. The first is that the clearance process in Australia should change according to the ACCC. In most other jurisdictions, it's a formal process. It is also suspensory, so the merger can't be completed until the regulator signed off. But in Australia, we have a totally voluntary system, which is a unique aspect of Australian merger law. Also, a number of changes have been proposed to the merger test, including the definition of likely, and finally, some specific tailored changes in relation to digital platforms. So they're the three main areas of proposed changes. Okay, the reasons for the changes were set out in Rod Sims's speech. And the first point that he wanted to focus on was market power. And he focused initially on Australia and pointed out the fact that in Australia, a lot of markets are dominated by a small number of providers. And he he had a long list of industries: banking, supermarkets, mobile telecommunications, internet, energy, gas, insurance, pathology, domestic air travel, and social networking sites. So he's saying all those industries in Australia are highly concentrated, and he was saying that unless action's taken, this market power become further entrenched. It will hurt Australians, hurt consumers. He referred to the impacts on small businesses who only have a few buyers in many industries, focusing primarily on Coles and Woolworths. He talked about the incomes of farmers being squeezed by the companies that they deal with, and particularly the concerns in digital markets where consumers are exchanging access to their personal data for free services and really have no understanding, little choice or knowledge or control over how the data is being used. And he argued that these increases in concentration were leading to declines in productivity and wages growth. And there's sort of a strong inference of, the rich getting richer and the poor getting poorer in the arguments that he made. And as you can see there, he drew attention to the IMF's comments recently about the macroeconomic implications of increases in market power, which are, in their view, weakening investment, deterring innovation, reducing labour wages, and also creating problems for monetary policy. So a number of major concerns identified by the IMF. And he also quoted President Biden's executive order on competition, where he's indicated that over a period of time, there's been an increase in concentration in the US, and Americans are being denied the benefits of competition, that there's widening racial income and wealth inequality, and a sort of a criticism of previous Republican governments there, I believe. But the most important point is that this is a pretty bipartisan view in the US. Both sides of politics believe there's too much concentration, and many of the proposals being put forward in the US have support from both sides of politics. Other issues which support the changes are the evidentiary problems with the ACCC believe are inherent in the current law. Their view is that the courts tend to focus too much on the likely state of competition in the future and not look enough at how the acquisition will actually change the structural conditions of competition in the market in the present day. And also they are sceptical about how the courts are looking at the parties' commercial ability and incentives to engage in harmful behaviours, that they're sort of downplaying those issues a bit. Rod Sims points to the US and holds them up as an exemplar, in a sense, to say that they tend to focus more on the underlying economic and commercial thinking of the merger parties and how that is going to impact competition now. Whereas in Australia, we tend to really be too optimistic in thinking that the market will overcome problems of competition, that new entry will rapidly occur, and that large players will simply compete rather than enter into some sort of interdependence in markets. So I don't know if that's entirely right, but that's the view the ACCC's put forward. It also has argued that our laws in Australia are different to overseas. I think that's really related to the third point there, that the fact we have a voluntary, non-suspensory merger clearance scheme is different to virtually every other jurisdiction. It's been considered a bit of a strength actually in Australia, but he sees that's a problem for a variety of reasons. And also he sees a significant gap in relation to digital platforms, that the current law is not able to capture the anti-competitive impacts of digital acquisitions, particularly in relation to killer acquisitions, which is defined as an acquisition designed to prevent the emergence of a challenger company in a market before they achieve any strong position in the market. And he points to the fact that the big four, Google, Apple, Facebook, and Amazon, are serial acquirers, that over the period from 2010 to 2020, these companies together have acquired 500 businesses, approximately 4 a month. So he thinks that's a problem, that they're just acquiring these nascent competitors at an early stage and capturing the innovation these firms are offering. So the proposed changes that he has put forward, firstly, the new formal merger regime, he argued, was required because there have been examples, increasing examples, of companies failing to notify the ACCC and putting the ACCC under pressure. Recently, the IVF case, where the parties refused to suspend the merger pending the ACCC investigation. The ACCC was forced to go to court and get an injunction, which they were successful in doing. But increasing examples of companies taking on the ACCC, a strong argument that companies aren't providing fulsome or even correct information to the ACCC, and that's considered a bit of an abusive process. The voluntary scheme is based largely on trust. You know, the ACCC has to trust people, merger parties, to provide the accurate information, and if that's not happening, then the whole system falls down. The other issue is the cost implications of any change. So the way the ACCC wants to have the system operating is that there be specific thresholds above which companies must notify the ACCC and provide a predetermined range of information, and then the company would not be allowed to proceed with the acquisition until the ACCC had signed off on the acquisition. Under those thresholds, the current pre-clearance system would operate, pre-assessment system would operate, so that wouldn't be any change there. However, the ACCC also wants a call-in power, so where a merger may not hit the thresholds, the ACCC still wants the discretion to contact the parties and call in the merger so that they can look at it. And that's where they have concerns that there might be competition issues which are not fully reflected in the market shares of the parties. And then the parties were required to provide particular upfront information. There'd be a phase one request for information, and then if the merger wasn't clear to that level, then there'd be a phase two. So this is very similar to the European approach, and even in the US they have a similar first and second request process. Interestingly, there'd be a merger review process, but it'd be limited merits review to the Australian Competition Tribunal, so effectively excluding the federal court from the merger field. And finally, the tribunal would only be allowed to consider the material that was available to the ACCC when they considered the merger first time round. Now, the cost implication of this is significant. Currently, the voluntary scheme is very cheap, but this is obviously going to result in quite a lot of costs for everybody involved. The delays will be significant. It'll take a lot longer to get clearances because a lot more information will have to be provided up front. So it's going to be very costly, likely to be an application fee too when making a merger application. So that could be quite a large amount of money. Now, also proposed a range of changes to the merger test. The first is changing the merger factors, and the ACCC believes that the current factors are a bit skewed towards reasons why the merger should be allowed to occur, and so they want to change that balance a bit, but also to revise the merger factors to focus more on the structural conditions for competition and how they've changed to resolve the acquisition. Also, they want some new factors included in there to consider how the loss of competitive rivalry or an increase in access to or control of data may be an anti-competitive impact arising for an acquisition. So obviously some new factors that focus more on the whole data access side of things, and obviously focus very much on digital platforms. Also, they wish a change to the term likely. Currently, the test is effectively that on the balance of probabilities, there's a real commercial likelihood of a substantial illness and competition, which is a difficult test for the ACCC to establish. So what they would prefer instead is that likely be defined as a possibility that is not remote. So they reckon that that definition is consistent with the definition which applies in other provisions, such as the cartel provisions of the Act. So a possibility that is not remote would be a significantly lower standard for the ACCC to meet. The third major change is actually having a new provision that creates a deeming effect on companies with a substantial degree of market power. So effectively, if there was a company which had a substantial degree of market power in a market and it was seeking to acquire a competitor, and as a result of that acquisition, the substantial degree of market power of that company would be entrenched, materially increased, or materially extended, the company would have to prove why the merger was not anti-competitive. So basically, it'd be putting the onus on the merger parties to prove why the merger was not anti-competitive. So that's probably one of the most controversial aspects of the proposals. And there's a final change which is fairly limited in its application, but it arises from the Pacific National case where there was a related agreement which, due to the anti-overlap provisions in Section 45 of the Competition Consumer Act, it couldn't be taken into consideration in the merger assessment. So they want that changed. So the sort of related agreements that they can come into the mix when the anti-competitive effects of the merger are being assessed. Now, as I said, the Pacific National example is the one which has led to this particular change. From my experience, it's not an issue that comes up regularly, so it's a fairly limited change, I think. Now, the final major change is in relation to digital platforms, and what the ACCC has proposed here is a tailored test which applies to clearly defined categories of digital platforms. So it's not going to apply to every digital platform, only particular ones, and they'd be looking at types of companies which basically, given their size or scope, are significant players in the market, whether they're a gateway firm which is able to control how other businesses interact with consumers. So I think we all know who they're talking about here, but it'd be a test to determine which firms would be subject to these new laws. And the ACCC hasn't reached a final view on how this would work, mainly because there's a lot of activity going on overseas about this. So they're going to try and learn from what particularly the UK and the Europeans are looking at doing in this space. But effectively, they believe that the probability of competitive harm that would have to be met to stop a merger would be significantly lower than would apply to other acquisitions. They also want to have the power to stop acquisitions before they have a chance to develop into a major anti-competitive impact. So they're worrying about these killer acquisitions, stopping the major digital platforms from buying out competitors before they become full-blown competitors. So they think that this is an important change, but it is very dependent on what's happening overseas. And there they mention the strategic market status approach, which has been adopted in the UK, where the Competition and Markets Authority will apply this bespoke test to designated digital platforms to work out whether they have strategic market status. And if they do, then they'll conduct an upfront assessment of whether the conduct the company is engaging in will potentially lessen competition. And the test incorporates both traditional sort of market power approaches, but also a range of broader concepts, such as, you know, the access which the company will be getting in relation to consumers, whether they have the ability to change the rules of the game for businesses in a wider market. And the interesting thing here is the ACCC at that stage, when it issued its statement on these proposed changes, referred to the European Commission and the Digital Markets Act. And at that stage, there hadn't been much talk about what they were going to do. But since then, there's been talk about a new market investigation mechanism to be introduced into Europe, which moves beyond the confines of the traditional relevant market definition and focuses much more on market structure and competitive processes. So that's another guide that I think will influence the ACCC's formulation of its proposals. So just the conclusions, I think it's fair to say that when the ACCC issued its blueprint for changes, it took everybody by surprise. They were much more extensive than most people had anticipated, and it seems that the response from the Treasurer and the government has been pretty cool. They're not too interested in these changes and not satisfied there's a real case for change. The interesting issue here is with the federal election coming up, I think any real movement on these issues is being postponed till after the election. So it'll depend on which government's in, whether they're interested in these particular changes. The other interesting development or important development is a change in chair at the ACCC. So Rod Sims is leaving and Gina Cass-Gottlieb is coming in. And it'll be interesting to see if she's quite as committed to these changes as Rod is. And we're yet to find out what her views are. And clearly the overseas developments are going to be very influential. Like I think the ACCC will have a much stronger case to get its proposals forward if it can point to developments in Europe and the UK and the US that mirror some of these changes that they've proposed. Now, just a commentary on some of these proposed changes, like I think some of them have a good likelihood of getting through. I think the formal suspensory merger clearance process is likely to get through. I think you know, we are different to every other country that I'm aware of in terms of having this voluntary system. I think it's a real shame that we're losing the voluntary system because I think it benefited everybody. It was quick, efficient, it was not costly. But as I said earlier, it relies on trust. And if people are gaming the process and not providing accurate information or not allowing the ACCC adequate time to investigate a merger, then the system falls over. So I think it's inevitable that the system will become a compulsory process and much more bureaucratic and slow. The changes that I think are unlikely, I'm not too sure the government wants to start making changes to the definition of likely in the Act. I think that's a bridge too far, particularly as the remote possibility test seems very low. So I don't think that's got a lot of prospect. I also don't think that the proposal to cut the federal court out of determining merger decisions is likely to get much support. So they're unlikely to get through. Some of the other changes will probably be accepted. I think changes to the merger factors is not a big change. Amending the anti-overlap provisions isn't necessarily a big deal. I think the proposals which have the most prospect of getting through, in addition to the clearance procedures, is the digital platforms, effectively special legislation. There's so much happening overseas. There's a bipartisan support in many countries. And I think any proposals that are put forward there are likely to get a good hearing. That'd be well thought through and well developed. But the more that the ACCC mirrors overseas developments, the more likely they're going to have to get those through. The final issue is, I think the ACCC needs to be honest with itself and look at its record in litigating and ask itself whether it's been conducting those cases very well. I think there's been a real failure in operating or running the litigation in mergers well. There are probably a variety of reasons for that. I think sometimes there's inexperience in the people running the cases. I know that the Metcash case is a good example where there was a lot of lack of clarity in the case theory that was being proposed. The counterfactual was changed a few days into the trial. You had the TPG Vodafone case where the industry expert for the ACCC didn't actually provide evidence in support of the ACCC's case theory. These are pretty fundamental mistakes. So I think one thing that Gina Cass-Gottlieb should do when she takes over is do a comprehensive review of the way the ACCC runs its merger litigation to find out where they're making mistakes. And I think they need to address that as well, because some of these cases that they lost, arguably, they really shouldn't have lost. They had a pretty solid case, but didn't present very well. So that's all I had. If you have any questions about this presentation, feel free to give me a call or drop me an email. Bye-bye.